So, non-public subjects, I'm sorry, I'm correcting. I don't have to say subject because they are not subject in international law. Non-public persons, private persons, they are not public authorities. They don't have a legal statute of subject in the international legal order, but they are getting more and more importance. I would like to make a remark on that, a conceptual remark. Public authorities are losing their capacity to ensure the public general interest. So, sovereign states are losing their function of realizing the international public order, the international peace, the international general interest. And this gives a chance to private authorities, to private persons, to private initiatives like NGOs, firms, individuals, of the civil society, the international civil society, to get more and more responsibility, more and more importance, liability, more and more occasion to act in the international legal order. The sovereignty becoming very, very slowly a matter of people rather than a matter of states. And let me explain a point on that. The sovereignty is mixed, is used always with the term state in international legal order. When we are studying international law, we use always this expression, which is sovereign states. This formula, this expression is very true for the international law, but it is controversial. It is on discussion for the public law in general, for the philosophy of public law in general. Because when you say sovereign state, you are meaning that the sovereignty is owned by the state. But in many countries, many democratic countries, many republic or many monarchy also, modern monarchies. So in a lot of contemporary states, democratic states, sovereignty belongs not to the state, but to the people. It is national sovereignty, it's a popular sovereignty. Especially in democratic countries, the concept of sovereignty is used for democratic means. We are not talking about sovereignty of the state in constitutional law. In constitutional law, for example, in Turkish constitutional law, in French constitutional law, in German constitutional law, publicists are talking not about state sovereignty, but sovereignty of people. Why I am telling that? Why this remark? Why this precision? Because you understand that the evolution of international law is an occasion for the real owners of the sovereignty, which are not states but people, to intervene in the realization of the international, in the creation of international standards, of international norms. So I hope it's not too difficult for you to understand that people are not subjects of international law, but they are getting more and more importance because they are trying to exist, to be balanced, to be taken in consideration by sovereign states. So this was the remark about the sovereignty and the evolution of international law, the taking account of individuals. But this evolution, and this is another reflection, another discussion about individuals. All this evolution doesn't change legal qualifications. So private persons are not and will never be legal subjects of international public law. In a legal speaking, we cannot consider persons, private persons, firms or particulars as international subjects, even though their existence and their acts have impacts on international law, and even though the international law can establish duties or rights, legal obligations or legal rights for individuals, those individuals will remain simple objects of international law and not legal subjects. Of course, there are very tiny exceptional situations. The situation, for example, of chief of states or diplomatic workers of a state or workers of an international organization. Those persons, those particulars are not considered as private persons. They are the emanation of public authority. So a chief of state or a prime minister, which benefits from immunities, diplomatic immunities, international immunities, it is not considered as a private person. Chief of state and prime minister can conclude treaties. They are competent authorities of the state. But in this case, they are not acting as private persons. So it's not a real exception. Private persons are never legal subjects in international law. But they can have duties, legal obligations in the one hand, or rights in the other hand. I would like to give you some examples of legal duties, and then I will finish my intervention by giving you some examples of legal rights. International law created several duties, for example, in matter of workers. In matter of workers, in social protection, in international social protection standards are created by the International Labour Organization, ILO, ELO, International Labour Organization, adopted, for example, a declaration of principles concerning multinational enterprises and social policies. Principles concerning multinational enterprises and social policy in order to prevent the excessive, strict, excessive, harmful working conditions in several countries applied by several big firms, international firms. Another example for this kind of social protection is the Raji principles. Raji principles. Raji is written with an R, U, 2G, E, I, E. Raji principles. After the disaster in Bangladesh in 2013, a duty of vigilance for human rights in the firms, in the multinational firms, for the multinational firms, is adopted, for example, in France. It is applied. There are other examples for in criminal matters. In criminal matters, the Council of Europe created a civil convention on active corruption in order to prevent the use of firms, companies, of some corruption techniques on several countries. So there are many obligations, duties imposed to international companies. But there are also rights. There are also rights. For example, one example in the international general law, before the International Court of Justice in 1970, we have a case on Barcelona Traction Company, in which the International Court of Justice admitted that there are rights for international companies to be protected by states in the jurisdiction of their states. Another example is the application of the European Convention on Human Rights. The European Convention on Human Rights is giving many fundamental rights to private persons, and also it gives in its Article 34 a right to individuals to make an application directly before the Court of Human Rights, before the European Court of Human Rights. So, the international law can give to a private person the right to seize, the right to go before an international court of justice, an international institution, and before the European Court of Human Rights. But the only fact that a person has rights or duties in international legal order doesn't make this person a legal subject or a creator of legal norms in this order. The legal personality is the right, the capacity to have rights and duties, and the capacity of acting in the legal order. But as they cannot conclude treaties, they cannot create norms, legal norms, persons are not legal subjects in international law, even though they can sue a sovereign state before an international judge, as we saw in the example of Article 34 of the European Court of Human Rights. So thank you for your attention. If you have questions, I can take them. If not, we will see you next week. Thank you.